parties have got a disagreement, maybe if they are trying to bargain for better standards, and then they do not agree. So it's an interest because there is no legal obligation that has been breached. And in terms of Section 93, where a labor officer has issued a certificate of no interest, and it is a dispute of interest, and the parties are involved in essential services, then the Act is obligatory that such the labor officer shall refer that dispute to compulsory arbitration. And then as for the dispute of right, there is a may, after issuing a certificate of no settlement, the labor officer may refer the dispute of right to compulsory arbitration. And where the parties agree, then the dispute of right can be referred to voluntary arbitration. Thank you.
The second question is as follows. What steps must a labor court judge take to properly address and decide a constitutional question arising during its proceedings, if any?
Thank you, Chief Justice. A labor court judge has got 3 options that he or she may take when a constitutional issue arises during the proceedings in a labor matter. The first, a judge may more to refer the issue to the Constitutional Court, or where one of the parties requests that the constitutional issue be referred to the Constitutional Court, and if the judge considers that the request is not vexatious or frivolous, then the judge must refer the issue to the Constitutional Court. And then the third option is where a constitutional issue arises, the judge of the labor court may decide to resolve the factual issues and then leave the party to raise the constitutional issue on appeal. And the judge is required to get submissions from the parties as to the specific issue which the judge requires the Constitutional Court to decide on. Thank you.
The third and last question is as follows. What is the appropriate test for determining whether the labor court's factual findings are, quote, so grossly irrational, unquote, as to warrant appellate court interference in labor appeals.
Thank you, Honorable Chief Justice. Generally, superior courts are adverse to interfere with factual findings of inferior courts. However, where the Supreme Court considers that the finding that was reached by the inferior court was so grossly unreasonable that no court acting reasonable could have arrived at such a decision. Therefore, the court will then interfere with a factual finding. Thank you.
Thank you. I'll now hand you over to the other commissioners for further questions if they have them. Yes, CJ.
Yes, thank you, Honorable CJ. Good afternoon, Mr. Msiete.
Good afternoon, Deputy Chief Justice.
Yes, I have one question for you. Given the scope of the matters that appear before the Labor Court, can you list the possible agents that may represent parties before the court as highlighted by the Labor Act?
With due respect, Deputy Chief Justice, may you please repeat the questions?
Yes, okay. Given the scope of the matters that appear before the Labor Court, can you list the possible agents that may represent parties before the court as highlighted by the Act, the Labor Act?
Thank you, Chief Justice. The following is a list of those that may represent parties at the Labor Court. As a registered legal practitioner, with a practicing certificate, of course, a trade union employee, a registered trade union employee or representative, a workers' committee representative can represent a party at the Labor Court. Those are the three that I can think of now. Thank you.
Yes, thank you for your answer.
Questions, Chief Justice?
Thank you, Chief Justice, and good afternoon, Mr. Mziet.
Good afternoon, Commissioner.
You will assist me in pronouncing the name. I may be pronouncing it wrongly, and I don't want those that come after me to follow. If I may be assisted, Ms. Yekle, no?
Right, it's Mozeche. Yes, yes.
Mr. Muzech. Now, the question that I have for you is this. What are the potential legal consequences for an employee who resigns without giving proper notice, and how should the Labour Code interpret such a resignation under Zimbabwe's labor legislation and principles of fairness?
Thank you, Commissioner. In terms of the Labour Amendment Act of 1923, an employment contract may only be terminated on the part of the employee by resignation or retirement. And in terms of that amendment, there is no way it is required on the part of the employee to give notice of resignation. However, there is another section whereby, which has not yet been repealed, which has got period of notices for different contract of employment. And usually the employers fall on that section to say, we agreed that you are going to, you will give 3 months notice, you will give 2 months notice on resignation. As such, we are going to hold a certain amount as penalty for not giving a notice. But if you look at the import of that new amendment, it does not give an obligation to the employee to give a notice when resigning. It is the employee who would have chosen to retire or to resign without giving a notice. As such, the Labour Code, I'm inclined to think that when interpreting that new amendment, it will lean in favor of the employee, and there won't be any adverse consequences for resignation without a notice. Thank you.
Thank you, Honorable Chief Justice, and good afternoon, Mr. Mzeche.
Good afternoon, Commissioner.
I'm looking at your CV on previous work experience. There is GMB 2010 to 2020. Then on current employment, there is GH Muzondo and Partners, but you do not specify when you joined GH Muzondo and Partners. Would you like to clarify that?
Okay, thank you, Commissioner. I joined GH Muzondo and Partners in January 2021.
And what is your role? Are you a partner or you are an associate or what?
At the moment, I'm an associate.
Thank you, Honorable Chief Justice. I have no further questions.
Thank you, Honorable CJ. A good afternoon to you.
Good afternoon, Judge President.
Yes, I do have one question for you. What mechanisms exist under Zimbabwean law to enforce the right to equal remuneration for similar work provided for under Section 65 of the Constitution of Zimbabwe, 2013?
Thank you, Honorable Judge President. The mechanisms that are provided in Zimbabwean law to enforce a right of equal remuneration, obviously, if there is a breach of that right, the aggrieved employee may use the workplace some code of conducts have got mechanism where if you have got a grievance, there's a grievance procedure that you can follow. You start with your immediate superior, and then you go on up to the highest authority in that workplace. If there is a grievance, you can also use the works council at the workplace to try and resolve that grievance. But if the grievance is not resolved, then it becomes an unfair labor practice. And an unfair labor practice can then be referred to a labor officer to try and resolve it in terms of Section 93 of the Act. Thank you.
Thank you. Thank you, Honorable CJ.
Thank you, Chief Justice. Good afternoon, Mr. Mzieje.
Good afternoon, Honorable Commissioner.
Under the Labor Act, what is a collective bargaining agreement? What is a collective bargaining agreement? The second component of the question is, what are the prerequisites for its validity?
Thank you, Commissioner. A collective bargaining agreement is an agreement that is reached between the employer's representatives and the employee's representatives. It is reached at a National Employment Council for that industry. That is, if there is a registered National Employment Council for that industry, then the employer's representatives and the workers' representatives then negotiate for better working conditions. And where they reach an agreement, then it is signed by those representatives. After signing, then the collective bargaining agreement can then be sent to the responsible minister so that it is made a statutory instrument so that it will be binding and enforceable to the parties. And the prerequisite for its validity is obviously the registration so that it becomes a statutory instrument. Thank you.
Are there any other pillars that constitute the basis for the validity of collective bargaining agreement beyond its registration?
At the moment, I don't have recollection of any other pillars.
Oh, that's fine.
Sorry.
Thank you.
Thank you.
Thank you, Honorable Chief Justice. Good afternoon, Mr. Muzeche.
Good afternoon, Honorable Commissioner.
I have one question for you. It goes like this. How does Section 90, capital letter A of the Labour Act relax strict rules of evidence and procedure? And what limits remain to prevent injustice through procedural laxity?
Thank you, Honorable Commissioner, for that question. That section provides that the Labour Court is not bound by strict rules of evidence, and it can clarify issues in such a manner that it will do justice and in an equitable and expedient manner. And the limitations which are there, obviously, where the Labour Court is not bound by strict rules, it does not mean that each thing should be approached in a laissez-faire attitude. They ought to ensure that the manner that the evidence is being admitted is not unjust to the other party and is not prejudicial to the other party. Those are the limitations which I can think of now.
Thank you very much. Thank you, Honorable Chief Justice.
Thank you, Chief Justice. Good afternoon, Mr. Mzeche. Looking at your CV, you have practiced law for a total of 7 years. You did 2 years from 2008 to 2010, and you have been in practice now from 2020. Do you think that is sufficient experience in the practice of the law to equip you for the office of a judge of the Labour Court?
Thank you, Commissioner. I'm confident that the experience that I have is relevant and enough for me to be appointed as a judge of the labor court, in that I've gone through the meal in terms of labor, that is the practical experience as an employee, as an employer's representative, as a member of a National Employment Council, Works Council, negotiating with employees, and also representing the employer in labor matters when we're at GMP in order for us to reduce costs where matters will go before labor officers. I will either go as the corporate secretary or the legal officer who was my assistant. And that gave us experience in handling labor matters. And also, I've sat in various hearings in terms of the Registrar's Code at GMP, and also in terms of the Statutory Instrument 15 of 2006. As such, I've gained significant experience, and also the strategic planning, a master's in strategic planning degree also has enhanced my understanding of the complex labor disputes that characterize the industry. And now, as a lawyer in private practice, I've handled a number of labor issues representing employees. Most of the issues go up to the labor officer, and I've got one which has gone up to the labor court. And taking my legal expertise, my experience, and my maturity and wisdom that I've gained throughout the career, I think I'll be an asset to the Judicial Services Commission, and I'm ready to help the Judicial Services Commission in the improvement of the justice administration system. Thank you.
When you say you've had one matter go up to the labor court, do you mean since 2020?
Yes, since 2020, there's only one matter that went to as far as the labor court. The rest of the matters have gone up to labor officer level, or where I represent the employees before a disciplinary authority or disciplinary committee. They will either end there, and they will not go as far as the labor court.
And have you only represented employees? Have you represented employers at all?
I represented the employer when I was at GMP. Yes, that is the time that I was representing the employer. But after I've left GMP, in private practice, I've only represented employees. Those are the clients that we have had at GH Muzondo and Partners.
Thank you, Chief Justice. I have no further questions.
Thank you, Chief Justice. I have no question.
Yeah, thank you. We have come to the end of your interview. You are excused.
Thank you, Chief Justice, and the rest of the commissioners.
Yes, just confirm, we have Ndiroway Donald Osmond.
I confirm, Honorable Chief Justice.
Yes. As I indicated this morning, I'll be asking you 3 questions. The first question is as follows. What distinguishes a dispute of interest from a dispute of right under Section 93 of the Labor Act? And how does that classification determine whether arbitration is voluntary or compulsory?
May you kindly repeat the question, Honorable Chief Justice?
What distinguishes a dispute of interest from a dispute of right under Section 93 of the Labor Act? And how does that classification determine whether arbitration is voluntary or compulsory?
Thank you, Chief Justice. I will start with the difference between a dispute of right and a dispute of interest. A dispute of interest is a dispute which pertains to new rights or benefits of the employee. And when there is a dispute of that nature, if the matter is referred to a labor officer, he can refer the matter to compulsory arbitration. Then the dispute of right concerns, or it's a dispute which concerns the rights and obligations of an employee. And it can constitute unfair labor practice, and this type of a dispute can be referred to voluntary arbitration. That will be my answer to that.
The second question is as follows. What steps must a labor court judge take to properly address and decide a constitutional question arising during its proceedings, if any?
Sorry, Chief Justice, can you kindly repeat the question for my benefit?
What steps must a labor court judge take to properly address and decide the constitutional question arising during its proceedings, if any.
Thank you, Chief Justice. That judge, when a constitutional issue arises and any of the parties raises that constitutional issue during the proceedings, the judge must refer that issue or question to the Constitutional Court if he considers that the request is not frivolous and vexatious. I also believe that that judge can refer the constitutional question to the Constitutional Court mero moto. That will be my answer, Chief Justice.
The third and last question is as follows. What is the appropriate test for determining whether the Labour Court's factual findings are, quote, so grossly irrational, unquote, warrant appellant court interference in Labour appeals?
Sorry, Chief Justice, I continue to seek your indulgence. I hope I'm not going to be a nuisance. May you kindly repeat the question? Yes.
What is the appropriate test for determining whether the Labour Court's factual findings are, quote, so grossly irrational, quote, as to warrant appellate court interference in Labour appeals?
My answer to that, Chief Justice, will be that the test is that the factual finding by the Labour Court should be or will be so outrageous in its defiance of logic that no reasonable person seized with that set of facts would have arrived at that decision that the judge would have arrived at. Put simply, the judge would have completely disregarded the facts that have been presented before him or her. That is my answer, Chief Justice. Thank you.
Yes, thank you. I'll now hand you over to the other commissioners to ask you further questions if they have them. Yes, please.
Yes, thank you, Honorable CJ. Good afternoon, Mr. Ndiroe.
Good afternoon, Honorable DCJ.
Yes, I have one question for you. Given the scope of the matters that appear before the Labor Court? Can you list the possible agents that may represent parties before the court as highlighted by the Labor Act?
Sorry, DCJ, may you come again so that
Yeah,
I
sure.
understand your question?
Given the scope of the matters that appear before the Labor Court, can you list the possible agents that may represent parties before the Labor Court as highlighted by the Labor Act?
Thank you, DCJ. I can only think of two at the moment. That is, if the matter pertains to a dispute which involves essential services, and also a matter that relates to collective job action. Those are the two that I can think of at the moment. Perhaps you can repeat the question so that I appreciate it.
Yes.
It was not recorded when you...
Oh, is that so? Okay, so it's okay now. Okay, I'll read it slowly. Yes. Given the scope of the matters that appear before the Labor Court, can you list, and this is where the crux of the matter is, can you list the possible agents as in AGENTS? Agents who may represent parties before the court as highlighted by the Labor Act.
Sorry, DCJ, I had taken the agents as whether or not
Yes.
the matter is agent.
Oh, okay.
Sorry about that.
Thanks.
In that case, I would say a representative of a trade union or a works committee can appear as an agent before the Labor Court, representing a member of that trade union or works committee. An HR manager or HR manager or personnel manager, company secretary can also appear as an agent representing a company that is involved in that particular litigation before the Labor Court. Thank you.
Thank you, Honorable Chief Justice, and good afternoon, Mr. Ndirowe.
Good afternoon, Commissioner.
Mr. Ndirowe, you were a registrar of the Labor Court for 2 years. Is that so?
Yes, I confirm that, Commissioner.
Now, can you tell the Commission about the experience that you got from that position and how you think it's going to assist you if you become judge of the Labor Court?
Thank you very much, Commissioner, for that question. As I've confirmed, I've been a registrar of the Labor Court for 2 years, and I can say the experience that I got during that stint is invaluable in my view, in the sense that I was charged with the day-to-day running of the labor court, both the administrative side and on the litigation side, that is implementing the labor court rules. I was also doing that in consultation with the senior judge and other judges of the labor court. So that gave me an edge or a wealth of experience that I can carry over to the labor court bench in the event that I am appointed a judge of the labor court. In short, I can say.
Yes, and having served in that very important position in the labor court, how do you see the labor court evolving in relation to technology and modern markets as we progress?
Thank you. Certainly, there is still room for the labor court to evolve. Right now, as we are talking, the labor court has gone paperless. By the time that I left the labor court, it was still a paper-based court, but the Chief Justice's vision had already started. We had started the work to make the labor court a paperless court. So I think with the advent of the ICMS, there is still room to improve the operations of the labor court in line with the technological evolution that is there. For example, I can say the issue of transcription of records still remains a challenge. I understand records are being manually transcribed. So I understand there is technology that can convert voice to print, to word or print. So I think that kind of technology is taken on board. It will surely.
Do you think if you were to go to the labor court as a judge, you would assist to a large extent in that process of evolution, moving with the times, so to speak?
Yeah, certainly. I'm confident that I can assist because when the Chief Justice brought the idea of the ICMS, I was one of the team of registrars whom I called pioneers in my questionnaire, who worked on the process documents, who were converting the rules and putting them in a form that is understood by the engineers who were working on the ICMS so that they understand the case flow of our matters. For example, if a matter is filed in the labor court, what happens from the filing right up to adjudication and passing of an order or a judgment. So I feel I still have the energy and the zeal to assist the JSC, particularly the labor court, in that regard, considering the experience that I gained. I hadn't. Oh, okay, thank you.
Yes, thank you. Yes.
Thank you, Chief Justice, and good afternoon, Mr. Ndirowen.
Good afternoon, Commissioner.
Now, here is my question. What are the potential legal consequences for an employee who resigns without giving proper notice, and how should the labor court interpret such a resignation under Zimbabwe's labor legislation and principles of fairness?
Can you kindly repeat the question, Commissioner, for my benefit?
I will do so. What are the potential legal consequences for an employee who resigns without giving proper notice? And how should the labor court interpret such a resignation under Zimbabwe's labor legislation and principles of fairness?
Thank you, Commissioner, for the question. I can only think of two at the moment. That could be loss of pensions and terminal benefits if one resigns without giving notice. On how the Labour Court should interpret that in terms of our laws, I would say resign on notice, because that is a unilateral decision that an employee can take and exercise that right. So in that sense, as long as the communication to resign is sent through the correct channel and to the correct authority, then that employee should not lose the pension and the terminal benefits, in my view. Thank you.
I think I need clarity from your answer. On one hand, you are saying that the law provides that such an employee who resigns without proper notice faces the prospect of losing the terminal benefits. And on the other hand, at the end of your presentation, you propose that the Labour Code should not sanction what you have already told us is the law. Unless I'm lost, I would need you to clarify that.
Thank you, Commissioner. Let me clarify my position. If I heard you correctly, you had said the potential legal consequences. So I thought those were the potential legal consequences. But in my view, the correct legal position is that there is no need to give notice, and they should those potential consequences that I've mentioned should not arise in the circumstances.
Thank you, Mr. Ndro, and thank you, Chief Justice.
Yes. Thank you, Honorable Chief Justice, and good afternoon, Mr. Ndirowe.
Good afternoon, Commissioner.
In your answer to the Honorable Deputy Chief Justice's question, you excluded legal practitioners as agents that may appear for a party in a labor matter in the Labour Court. Is it your view that a legal practitioner cannot be an agent for a labor litigant?
Thank you, Commissioner. Certainly that is not my position. I just mentioned, I think, two, but certainly legal practitioners are required by operation of law to take instructions from their clients and represent those clients before the Labour Court.
Thank you, Honorable Chief Justice.
Thank you, Honorable CJ. Good afternoon, Mr. Ndirowe.
Good afternoon, Honorable Judge President.
I do have one question for you. What mechanisms exist under Zimbabwean law to enforce the right to equal remuneration for similar work provided for under Section 65 of the Constitution of Zimbabwe, 2013?
May you kindly come again, Honorable Judge President, for my benefit?
What mechanisms exist under Zimbabwean law to enforce the right to equal remuneration for similar work provided for under Section 65 of the Constitution of Zimbabwe?
Thank you, Judge President. I think that will be issues to do with gender equality, non-discrimination on tribe or ethnicity, and perhaps we can also talk about maternity leave under that for female employees. That will be my answer to that one.
What are the consequences of breach?
The consequences will be that if these are infringed, then a mechanism right up to the Labor Court and the Supreme Court.
Chief Justice, good afternoon, Mr. Ndirowe.
Good afternoon, Commissioner.
Commissioner Masie Moyo. If you're currently a regional magistrate, right? Resign from the Judicial Service Commission tomorrow to resign to go and join another organization. Requirement for one to serve notice to resign from a job or from employment to go and join another organization?
Commissioner, in terms of the answer that I gave,
Yes.
it appears that that is the suggestion or the impression that I make.
That is what?
That is the impression that
The impression you get from?
from my answer that I gave.
Yes, that's the impression that I
Yes.
got.
I agree with you on that, but then you have to look at the regulations that binds
Okay.
the employment of the regional magistrate and the Judicial Service Commission. It then requires one to give notice.
Is that not the context in which the question ought to be looked at?
I would suggest so, but when I was then looking at the position of the law, it appears the position of the law says resignation is a unilateral act.
And I understand. I'm just trying to figure out if somebody said, well, there's no definitive position of the law. What actually subverts that specific provision of the law? That's the impression that I would take, is suggesting that that specifically require that individuals serve notice before they can resign.
Yeah, with the insight.
That would then give a satisfactory response to the answer.
I agree with
and,
you, Commissioner.
I suspect that a response of that nature would kind of clear the air for purposes of just avoiding the possibility that one goes away and says, the law in this country does not allow anybody to be required to give notice when they want to resign. Just an observation.
Surely, I agree with that observation. Thank
you. Let me come to my set of questions that I thought I should have a conversation with you on. Under the Labor Act, what is a collective bargaining agreement under the Labor Act?
Thank you very much, Commissioner, for that question. A collective bargaining agreement is negotiated agreements of the employer and the representatives of the employee or the employees. The prerequisites for its validity is that it should be ratified by the negotiators. It should also be registered as a statutory instrument for it to be binding. And once it is confirmed with those prerequisites, then it becomes binding on the employers and the employees, such that a breach of that CBA would amount to an unfair labor practice. That would be my answer.
All right, thank you.
Thank you, Honorable Chief Justice. Good afternoon, Mr. Ndirowe.
Good afternoon, Chief Magistrate.
I have one question for you. How does Section 90, capital letter A of the Labor Court Act relax strict rules of evidence and procedure? And what limits remain to prevent injustice through procedural laxity?
May you kindly repeat your question for my benefit?
Okay. How does Section 90, capital letter A of the Labor Act relax strict rules of evidence and procedure? And what limits remain to prevent injustice through procedural laxity?
Thank you very much, Chief Magistrate, for that question. Section 90A of the Labor Code indeed relaxes the rules of evidence, in that it provides that the Labor Court is a court sui generis, which is not bound by the strict rules of evidence. For example, the issues to do with admissibility of hearsay evidence. Such kind of evidence is admissible before the Labor Court. The limits that I can think of that have been put in place to prevent injustice is that the relevance of that evidence that is being led will need to be checked. That evidence should be relevant to the issues before the Labor Court, and the leading of such evidence should not prejudice any of the litigants that appear before the Labor Court. I don't know whether I should go further than that for the purposes of answering this question.
Yes, you could expound on that issue.
Perhaps I might also add that the presiding judge can also call witnesses to come to clarify certain facts or evidence that is before that court, or facts that need clarity, and the judge can put questions to the parties and even their representatives who appear before that court to clarify certain issues. That is something that cannot be done in our ordinary courts of law that rely on strict evidence rules. Thank you.
Thank you, Mr. Ndirowe. Thank you, Honorable Chief Justice.
Thank you, Chief Justice. Good afternoon, Mr. Ndirowe.
Good afternoon, Commissioner.
I have two questions for you. The first one is, we have information here that for the whole of the year of 2024, you only finalized 19 trials, 19, which is less than 2 trials per month. And that for the year 2025, January to May, where we are, you've only finalized 16 trials, which is a rate of 3 trials per month. How do you explain that work output, and how do you think that prepares you for the pressure of the Labor Court?
Thank you very much, Commissioner. Can you repeat the last part? I didn't hear the last part of your question.
I said, how do you explain that work output, and how do you think that prepares you for the pressure of the Labor Court?
Thank you very much, Commissioner, for that question. Well, I should admit that the statistics or the figures are bad, considering the expectations of the Judicial Service Commission on the work output. Particularly, I would give the expectations, the threshold that we have as a department is that you should complete at least between 10 to 15 meters per month. 19 trials, certainly those figures are awful, and I must admit that that should not happen under whatever circumstances. So I will not try to defend these statistics here as I sit here. It's something that we have discussed with my supervisors, and I've taken measures to improve the statistics. And in 2025, I promised my supervisors that the output is going to improve. And right now I'm on 16. Despite the fact that the whole of March I was on leave this year. So I would not want to defend those statistics at this stage. Thank you.
The second observation I make on your CV is that you have moved a lot. You have moved a lot within the JSC. From provincial magistrate, you went to, I think, Deputy Registrar High Court 1 year, Registrar Labor Court 2 years, Registrar High Court 4 years, Deputy Head Corporate Services 1 year, now Regional Magistrate. How do you explain that movement?
Thank you very much. Indeed, that is a fact, Commissioner. But my explanation to that is that the JSC as a body is full of opportunities. So those are the opportunities that came my way, and I seized them. Thank you.
If we make you a judge and an opportunity passes, you'll follow it and leave us in the lurch?
No. Like I said, those opportunities arose within the JSC. So if an opportunity indeed arises within the JSC For example, in the event that I'm appointed labor court judge, if an opportunity arises that I should move to the High Court, then I'll seize it.
Thank you, Chief Justice. I have no further questions.
Thank you, Chief Justice. Good afternoon, Mr. Ndiroe.
Good afternoon, Commissioner Dr. Katsande.
Yes, I have one question for you. Does the Labour Court have unlimited jurisdiction over all matters?
Thank you very much, Commissioner. The Labour Court does not have that kind of jurisdiction. That is unlimited jurisdiction over all matters. It simply has got jurisdiction over those matters that are specified in the Labour Act in terms of Section 89 of the Labour Act. That will be my answer.
Okay, thank you. Maybe I left a very important part. The matters I was referring to are not just all matters, but all labor matters.
With that qualification, then I would say the Labour Court does not have unlimited jurisdiction over all labor matters. There are certain labor matters that do not fall within the jurisdictional limits of the Labour Court as provided for by the Labour Act in Section 89. The examples that can come to mind is that a Labour Court cannot issue an interdict. A Labour Court cannot deal with mandamus and declarators. Thank you.
Thank you, Chief Justice.
You were once a magistrate before you went to administration.
I confirm, Chief Justice.
And you went to administration, I think, at the time when the Judicial Service Commission was embarking on a very aggressive transformation agenda. Is that correct?
That's correct, Chief Justice.
And during that time, up to now, the JSC cannot it really cannot sort of see itself giving up or sacrificing on the sustainability of that agenda. You agree?
Yes, I agree, Honorable
And
Chief
it
Justice.
would need a high-level performance.
Certainly, Chief Justice.
Yes. And that has been the principle, you know, right through.
I know,
That
Chief Justice.
it's been sustained and it continues to be sustained by very high-level performance.
Certainly.
Now, with this mobility of office from one office in administration to another within a short space of time, how would you rank your performance? Are you a high-level performer? Are you a medium performer, or you are a low performer? You are a lower level performer.
I would say, Chief Justice, I'm a high performer.
You're a high performer.
Yes, Chief Justice.
Wouldn't a high performer stay on? Not move 1 year, you're gone. We value high performers, I can tell you. We would not see high performers living in a year. In 10 months, you are moved from one office to another to leave room to others to take over from you. Is that how an organization would preserve its resources? human capital. I don't think JS is like that. So would you consider your movement, because you have moved quite a lot, as Commissioner Moyo has made it clearly and you admitted, you have moved, I think, almost 5 times within the administration itself. Since you left magistrate, you moved into administration. Within administration, you were moving around until you went back to the courts. Is that a sign of an employee of a high-performing capacity?
Yes, Chief Justice, I would react that if you check, you see that when I started the administration, I started at what I would call the lower level as a deputy registrar in the High Court. Then from there, I was elevated to the position of registrar of the labor court with more responsibilities than the position that I held of deputy registrar in the High Court. I was now in charge of the labor court as a whole and all the stations in Zimbabwe. And then from there, I was also elevated to a registrar of the High Court, a position which back then was a higher position than that of a registrar of the labor court. So in my view, that is a telltale sign of a high performer.
Yeah, but you have a lot of mobility within that context you are talking about. You
Yes,
don't stay.
Yes, Chief Justice.
Is it a sign of being efficient, or you could also cynically be being tested?
I wouldn't take
mobility. So your view is that this sign of mobility is a sign you are efficient, you are capable?
In the circumstances that
In
I've
the
explained.
circumstances.
Yes.
Right. I'm just asking this because then the statistics will then show, taking into account this mobility, seems to speak to something different from what you see yourself perhaps to be. Why would you, as a regional magistrate senior, be completing so few cases? You are doing you have admitted, I think, doing 19 trials only in 2024, the whole of 2024, when your colleague, one of the regional magistrates, was doing 105. You are supposed to be a senior with this experience you are talking about. You are doing 19 trials the whole year, and this certainly is against the policy of the JSC, you know it. Expeditious disposition of a case, of cases in all courts does not involve doing 19 cases a year. That's not a sign of competence. When another comparative person is doing 105, which is, the statistics don't lie, they are very clear and you accept them, then if that was perhaps a way of not, you had just some reason, you had not pulled yourself up, you repeat it. You continue in 2025, where a colleague of yours has already, as we speak, done 50 cases, and you have done 16. Now, surely that standard of yours doesn't show a high performer. The standard we are having to measure you against, and we measure now in JSC performance of judicial officers. That is the strictest policy which judicial officers must answer to. Now, you are a performer there, down there. You can see you need supervision, isn't it? You need somebody to tell you to work, isn't it?
I've considered, Chief Justice, that these figures are awful, in my words.
Yes.
But like I said, I'm reluctant to try and justify these figures. But there are certain considerations that I thought was not necessary to mention here.
I can tell you, we have heard that your colleagues coming in, those who tried like exactly in your position, doing exactly the same things. And they gave us stories about we are dealing with robbery cases or something like that.
No, that is not the, that is
What
not my
is your
situation.
excuse?
Yes, I was reluctant to say this, but now that you have asked me to say it, most of the time, I'm in the remand court, the regional remand court. So I'm not dealing with trials. I'm dealing with remands and applications for bail and so forth. So at the same time, I also have a trial court that I also man. So that can perhaps explain the figures, but it's something that we have discussed with my supervisors.
And we all come from there. We have all come from there. Regional remand cases cannot detain anybody. They are not like the ordinary remand of small cases of the remand court coming in. Regional are higher cases, and they are fewer, and they are normal. You cannot give an excuse of a remand of a regional cases as an excuse of not trying. Every regional magistrate knows that. To remand a case is to hear just next week or something, I need to try it, it needs to be tried. So what excuse are you talking about?
I agree with you, Honorable Chief Justice.
Yes.
But the remand court, court number 14, at Harare Magistrates Court, is not the ordinary remand court, in the sense that the traffic of cases in that court can detain you for a whole day. Sometimes I sit through lunch in that court, and sometimes it's pegged to the rafters such that we ask other litigants to go out of the courtroom so that I deal with those that can fit in the courtroom physically. And thereafter, we call the next group to come in. If you can make a spot check right now, that is what is obtaining at court number 14 at Harare Magistrates Court.
So that explains the 19 against 105.
I came to Harare Magistrates Court, I think in 2023.
I need to this recorded. You have been in remand court for 2 years, from 2024?
2024, I was 2 weeks in, 2 weeks out. 2 weeks in, 2 weeks out.
Yeah, you were not in remand court all the time.
Yes.
In 2024?
Yes.
Yes, but you still had this defect.
Yes, that's why I've considered, Chief Justice, that perhaps I concentrated more on the remand court than I should on my trial court. And we've since come up with interventions.
Now, we have taken a very strong position at the higher court, especially at the labor court as well at the moment, that we should have people who are self-motivated there, who work very hard, because we have one judge doing exactly like you, who's giving a headache. So one more is not enough. We have a judge who's giving us a headache there, exactly like you are doing. So you can see that the standard we are setting is that we don't want a situation like that to repeat itself. So how do you reconcile that when you want to go there with this record?
I agree with you, Chief Justice. That would be an undesirable situation. But if you check on the figures, they've actually improved from the 2024 figures to the 2025 figures. So I would take these as lessons that I would take as I move into the future.
Very nice if we spoke with you in 6 months' time, if you were lucky to come back, or somewhere else, or 1 year's time, and we see you have improved, as you say. Rather than us taking people who are not performing as performers. What standard are we enforcing as a commission?
Minus the qualifications that I've given, I concede, Chief Justice, that the figures are awful. And like I said, we have taken measures or interventions to correct the figures.
Yes, thank you. We have come to the end of your interview. You are excused.
Thank you, Chief Justice and Commissioners, for the opportunity.
Confirm we have Nzero Ignatius.
Confirmed.
Yes, thank you. As I indicated this morning, I will ask you 3 questions. The first question is as follows. What distinguishes a dispute of interest from a dispute of right under Section 93 of the Labour Act? And how does that classification determine whether arbitration is voluntary or compulsory?
Thank you. A dispute of interest is a misunderstanding or a disagreement that arises within parties who have an employment relationship whereby one party seeks to improve on the conditions of employment. Basically, that is one party seeks to or asserts that they have got an interest in trying to improve the conditions of employment. That is, it is futuristic. Whereas the dispute of right is a misunderstanding or a disagreement or a controversy that arises whereby a party asserts to a pre-existing entitlement. When it comes to whether or not a dispute of interest or a dispute of right can be resolved through voluntary or compulsory arbitration, a dispute of interest can be resolved through compulsory arbitration, whereas parties to a dispute of right can either agree to refer a matter for voluntary arbitration, but a dispute of rights cannot be resolved automatically through through compulsory arbitration. A dispute of interest can be resolved through voluntary arbitration by agreement between the parties concerned.
The second question is as follows. What steps must a labor court judge take to properly address and decide a constitutional question arising during its proceedings, if any?
Thank you. When a constitutional question arises during labor court proceedings, the judge can either, on its own volition, refer the matter to the constitutional court upon being satisfied that the dispute in question can only be resolved after resolution of the constitutional matter concerned. In that case, the judge will call upon the parties to address the constitutional matter in question. When the constitutional matter has been brought about by the parties, the judge can only refer the matter to the constitutional court if he is satisfied that the matter is genuine, that is, the matter is not frivolous or vexatious, which is meant to either raise unsubstantiated matters or either to frustrate the other party.
The third and last question is as follows. What is the appropriate test for determining whether the labor court's factual findings are, quote, so grossly irrational, unquote, as to warrant appellate court interference in labor appeals?
In order for the labor court to find that the facts grossly irrational. The court have to be satisfied that the facts in person or the facts in issue are irrational by looking at whether a different court can come up to a different conclusion or whether the facts have not been properly assessed for them to be considered as gross.
Yes, thank you. I'll now hand you over to the other commissioners for further questions if they have. Yes, CJ.
Thank you, CJ. Good afternoon, Mr. Nzero.
Afternoon.
I have one question for you. Given the scope of the matters that appear before the Labour Court, can you list the possible agents that may represent parties before the court as highlighted by the Labour Act?
Thank you. The agents that may arise from matters that appear before the Labour Court might involve issues where a right to a party in the employment relationship is in imminent threat, which require to be treated as a matter of agents.
Sorry, could I stop you there? The agents that I mentioned are agents as in AGENTS. Or maybe I should say agents.
My apologies for that.
Do you want me to read the question again?
No, I think I got it.
Okay.
Okay. The agents include a legal representation or a legal representative. They also include trade unions, which are properly registered. They can also include federations of trade unions. They can also include the employers representative or employers federations.
Yes, thank you.
Thank you, Honorable Chief Justice. Afternoon, Mr. Nzero. And now, can you tell the Commission about your interaction with the Labour Court?
Thank you. I'm mostly an academic, so the interaction that I have is through maybe research of cases, and also I edit judgments for the Zimbabwe Law Report, meaning there are also judgments that comes from the Labour Court that I also edit. I think that's the only interaction that I have.
I have no further questions, Honorable Chief Justice.
Need to clarify this. We don't have judgments of the Labour Court being reported, so they cannot have been edited. We are members of the board of editors, and we finally prove what you are talking about. There's never been any judgments of the Labour Court being reported. So I think we need to put it on record that it's not true. Judgments of the Labour Court are not reportable.
Yeah, that's true that they are not reported.
Yes.
But sometimes the distribution list contains.
They've never been.
They are distributed.
We are the people who appointed you. If you are talking, we are telling the truth that you are an editor, you are appointed by myself. And it cannot be. We have never appointed the editors to edit Labour Court judgments. We just wanted to make it clear. Okay.
Noted.
Sam, as a follow-up, would you like now to revise your answer to the question concerning the extent of your interaction with the Labour Court?
Thank you. So that means maybe the interaction that I have is maybe through some personal researches.
Do you mind repeating what you said?
I'm saying I'm mostly an academic. So as an academic, I do some research for publications. So from there, that's when maybe I pick some judgments that might come from the Labour Court. So that's the only interaction that I have, not through practice.
Thank you.
Yes, it's still a follow-up on those judgments because you actually committed on your questionnaire consciously. You said you had edited such judgments when in fact it can't be like that because those judgments are not given to you. Why did you do that? Why did you mislead the commission in filling the questionnaire?
It might have been an oversight, like what I have explained earlier on, that sometimes when we get the distribution list before we are allocated specific cases for editing, there are sometimes when you get maybe a folder with the Labour Court judgments. So not necessarily that ultimately the chief editor will allocate you to edit those judgments, but they might come as part of the broader distribution list.
Thank you, Chief Justice, and good afternoon, Mr. Zero. Now, good afternoon.
Afternoon.
Yes, your question from me is as follows. What are the potential legal consequences for an employee who resigns without giving proper notice? And how should the Labour Court interpret such a resignation under Zimbabwe's labor legislation and principles of fairness?
Thank you. An employee have got an obligation that arises from the employment relationship. In order to terminate the relationship, the law requires that an employee should give proper notice. So failing to give proper notice amounts to a breach of the employment contract. The consequence being that the employer is then entitled to sue for any damages that might have arisen as a result of failure to give proper notice. So the Labour Court, as a court, equity court, can uphold justice by trying to also ensure that the party to an employment relationship, in this case, the employer, have adequate remedies available to it in the circumstance where the employee fails to give proper notice.
Yes, by way of follow-up, would you be able to indicate where that law derives? The law that you have just unpacked, where does it derive from? In other words, is it? I don't want you to necessarily give me the details of the specific source of the law, but is it sources of law, right? So I want you to just briefly deal with that.
Thank you. The Constitution provides that every person has got a right to fair labor practice, and I will take it that fair labor practice can be interpreted to mean that the employer can also be entitled to such rights. The Labour Act also provides that the Act have to promote a social justice mandate, which is a basis upon which.
Sorry, Mr. Andet, I don't want to interrupt you. Well, not the generalized concepts. That's not what I'm looking for. Your fair labor practice, those are generalized concepts. Because we are now specific, we are dealing with the specific question. If you can't recollect where the source of the law is, still there is no problem. I don't know if you hear where I'm coming from. We're talking about specifics, right? So if you're unable to identify it, still there's no problem.
Okay, I will pass that on.
Thank you, Suche.
Thank you, Commissioner. Yes, Commissioner. Thank you, Honorable Chief Justice, and good evening, Mr. Nzero.
Good evening.
I have one question for you, which comes in two parts. And the first part reads, how would you construe the phrase redress and any dispute in section 63 3A of the Labour Act? And the second part is, does that phrase permit a designated agent to entertain appeals on the merits of a determination or only initiate conciliation?
Thank you. I think by redressing any disputes, this can be disputes that are within the jurisdiction of a particular tribunal or a dispute resolution authority. Then on the second part, a designated agent can only deal with or can only conciliate disputes that are within its jurisdiction or its powers, which are disputes where mostly that falls within the realm of conciliation. A designated agent don't have the authority to deal with, maybe, for example, disputes of rights, meaning they can only be limited to deal with disputes of interest, which are disputes which are within its authority.
Thank you, Honorable Chief Justice.
Thank you.
Afternoon, Mr. Nzero.
Afternoon.
Yes. My question goes as follows. What mechanisms exist under Zimbabwean law to enforce the right to equal remuneration for similar work provided for under Section 65 of the Constitution of Zimbabwe?
Thank you. I think the right to equal remuneration is part of the fair labor rights to fair labor practice can be enforced because it is a right. Parties who feel that their right has been violated, they can approach. Maybe they can seek firstly internal remedies through conciliation or arbitration, and lastly they can approach the courts for litigation to try and enforce their rights.
Thank you, Honorable Seat.
Dr. Nzero.
Good evening.
I just wanted you to take us through your understanding of what collective bargaining agreement is in terms of the Labor Act. What is a collective bargaining agreement? And the second part of the question is, what are the prerequisites for the validity of a collective bargaining agreement?
Thank you. A collective bargaining agreement is an agreement which is reached following a negotiation process between a representative of parties to an employment relationship. That is, it can be entered into between an employer and a workers' committee at the workplace level, or it can be entered into between a trade union or a federation of trade union at an industrial level. For a collective bargaining agreement to be valid, it must be entered into between parties who have an employment relationship. And also, it is an agreement, therefore, it must be voluntarily entered into. And for it to be binding, it must have been approved by the minister and enacted or it promulgated as a statutory instrument that is binding upon that particular industry or a particular workplace.
Okay, thank you very much.
Thank you, Honorable Chief Justice. I don't have questions for Dr. Nzero.
Thank you, Chief Justice. I have no questions for Dr. Nzero.
Yes, thank you, Chief Justice. Dr. Nzero, good evening.
Good evening.
Yes, my question to you is, does the Labour Court have unlimited jurisdiction over all labour matters?
Thank you. The Labour Court is a creature of statute. It is provided for by the Constitution of Zimbabwe. The Constitution provides for the it as a specialized court, and also the Labour Act specifically provides the situations where the Labour Court have exclusive jurisdictions, meaning that in other matters which are labor related, which falls outside the Labour Act, the Labour Court does not have unlimited jurisdiction. Therefore, like I said, that the Labour Court's jurisdiction is limited to the extent provided for in the Labour Act.
Thank you, Chief Justice.
Dr. Nzero, I've gone through your CV. You are an, excuse my say, you are a fairly accomplished scholar. Your CV attests to that fact. I hold of a bachelor's degree in law, master's degree, a PhD, and your research output is quite impressive. I mean, quite a significant number of publications in internationally refereed journals. And you have written books and contributed chapters to books, and you're quite active in the conferencing domain, and even at the universities where you have worked, you have supervised a very huge number of postgraduate students. And I would have thought that this is the domain of citizens that exhibit these kind of characteristics would be the universities. Now you would want to leave the university domain and be a judge of the labor court. Can you make me understand why that is the case?
Thank you. I really appreciate that. I think there are basically two reasons why I would want to join the bench. First thing is it's a passion that I always had. I remember when I wrote my first CV, when I joined the Ministry of Justice, I said I wanted to be a judge someday. So it's just something that I wanted to have. Then the second one is that the academia and the bench, I think we are just one side of a different coin, where we all try to promote the development of the law. Through academic work, we promote the development of law. Through the judiciary, you also promote the development of the law. As you have put it, that I think I've done my fair share in academia. So at some point, you'd feel that maybe you have acquired some skills that you can use elsewhere. So that's why I'm here for the interviews.
Thank you very much. Thank you, CJ.
Yes, thank you. We have come to the end of your interview. You may be excused.
Thank you.
Thank you. Yes, just confirm we have Tsikwa Clever Karikai. Yes, right. As I indicated this morning, I'll be asking you 3 questions. The first question is as follows. What distinguishes a dispute of interest from a dispute of right under Section 93 of the Labor Act, and how does that classification determine whether arbitration is voluntary or compulsory?
Thank you, Chief Justice. The distinction between the two, that is a dispute of interest and a dispute of right, is that as for a dispute of right, it is a dispute that arises from an already given legal right that is established in terms of either a collective bargaining agreement, an employment contract, or an employment contract, a collective bargaining agreement. These are the ones that give rise to a dispute of right. It is already an existing legal right. A dispute of interest, on the other hand, there is no legal basis for that particular right. It is a right whereby parties are still trying to negotiate, that still trying to bargain in order to establish that particular right. So a dispute of interest can be one that can be resolved through negotiation, collective bargaining, or it can result in collective job action. The determination or the distinction of those rights will determine which procedure is to be adopted. For instance, we are saying if it is a dispute of interest and the parties involved are engaged in essential service, it must be referred to compulsory arbitration. On the other hand, if it is a dispute of interest, the parties may, by agreement, agree that the dispute be referred for voluntary arbitration. If it is a dispute of right, it is referred to compulsory arbitration. That's my answer as Chief Justice.
The second question is as follows. What steps must a labor court judge take to properly address and decide a constitutional question arising during its proceedings, if any?
Thank you, Chief Justice. A labor court judge, when presiding over a matter and a constitutional issue arises in those proceedings, he cannot resolve the constitutional matter himself. The only option the labor court judge has is to act in terms of Section 175, subsection 4 of the Constitution. This provision has got 2 ways in which the referral can be done. If it is
a referral to be done by the judge, having realized that there is a constitutional issue that is arisen and that is tied or linked to the resolution of the matter before him or her. He then has to ask the parties appearing before him to address him on that issue. But the first thing the judge must do is to make sure that he formulates the question or the issue that is identified as the constitutional matter. Then he asks parties to present or to address him on that particular issue. Once that is done, he then has to formulate a constitutional question which must be referred to the Constitutional Court. But the first thing that must also happen is that there mustn't be any disputes as to the facts. If there are any disputes as to the facts, those must be resolved by the judge before making that particular referral, because the Constitutional Court does not deal with factual questions, but only constitutional issues. Then, if it is arisen in the proceedings and it has been raised by one of the parties to those proceedings, then the party who is moving the court for the referral must address the court on how that constitutional issue is arisen, must address the court on how it is linked or tied to the decision which is the court, or to the matter which is being presided over by the judge. Because what the judge must avoid is to be taken for some side shows, whereby somebody is simply making an application for referral when there is no, is not convinced the court that indeed the matter before the court cannot properly be resolved without first addressing the constitutional issue. So the party must be clear on those two aspects. Having done that, the parties must lead evidence on that particular issue so as to actually convince the court of the existence of that particular constitutional issue. Once that is done, if there is not much dispute or there are no disputes of fact, the parties must proceed to draft or draw a statement of agreed facts. If that is not done, the labor court judge, him or herself, must actually resolve the facts so much that what is only referred to the Constitutional Court is only a question, a constitutional question. And as to what a constitutional question is, the court must also be satisfied that what it is referring there is not a simple legal issue, but it is an issue which derives from the Constitution. And Section 332 of the Constitution would guide us on what a constitutional matter or a constitutional issue is. That is a question that involves interpretation, enforcement, and application of the provisions of the Constitution. Having done that, then the record is the judge having formulated the question, the parties have actually submitted arguments which they intend to motivate in the Constitutional Court. The record must then be prepared by the registrar in terms of Rule 24 of the Constitutional Court rules within a period of 14 days. And that record must be a copy of the record which contains either affidavits or statements by the parties motivating the arguments they intend to make before the Constitutional Court. I can say that is my answer, Chief Justice.
The third and last question is as follows. What is the appropriate step, what is the appropriate test for determining whether the Labor Court's factual findings are, quote, so grossly irrational, unquote, as to warrant appellate court interference in labor appeals?
Sorry if I may have it, if the question may be repeated.
What is the appropriate test for determining whether the Labor Court's factual findings are, quote, so grossly irrational, unquote, as to warrant appellate court interference in labor appeals.
The simple test there, Honorable Chief Justice, is that the factual finding that would have been done by the Labor Court must be grossly irrational as to be in defiance of logic. It is not consistent with the evidence, or not consistent with the evidence that is that would have been led before the Labor Court judge. It is so irrational as to be in defiance of logic. It is such that no reasonable court or reasonable judge would have come to that particular conclusion. Thank you, Chief Justice.
Thank you. I'll now hand you over to the other commissioners for any further questions if they have. Yes, to CJ.
Thank you, CJ. Good afternoon, Mr. Tsikwa. Yes, I have one question for you, which goes as follows. Given the scope of the matters that appear before the Labor Court, can you list the possible agents that may represent parties before the court, as highlighted by the Labor Act?
Thank you, Deputy Chief Justice. Parties that appear before the Labor Court may be represented firstly by a legal practitioner duly registered in terms of the Legal Practitioners Act. They may also be represented by an employee or representative from a trade union or employers organization. And thirdly, they may also be represented by a company secretary, a head of a Human Resources Department in that particular organization.
Yes, thank you.
Thank you, Honorable Chief Justice, and good evening, Mr. Tsikwa.
Good evening, Attorney General.
Mr. Tsikwa, there have been serious concerns that have been raised regarding your performance in the regional court. I hope you are aware, because the concerns have been brought to the attention of this commission, and they are to the effect that your rate of completing cases is below standard. Let me give you examples using figures, Mr. Tsikwa. The report indicates that in 2024, you only completed 39 cases. And in addition to that, you also removed 14 cases from remand. I'm not so sure what those cases are about, and being a regional magistrate, I only hope those are not cases of armed robbery. And it is also indicating in this report that currently you have only done 14 cases, 14 trials. But as a comparison, like for instance for 2024, your counterpart, your colleague, is done about 105 cases against your 39 cases. So this is very worrying, especially for someone who is, aspiring to become a judge of the Labor Court, because when such conduct is exported to the next court, it becomes very, very worrying and disturbing the process of justice delivery. Would you like to comment?
Thank you, Attorney General. My comment would firstly, I would not want to revisit these figures, because these are the figures that the Commission were given. So there is no contestation about that, because that's not the appropriate forum. My comment, having accepted the figures that we've given, would then be to try and proffer an explanation as to why the situation is as indicated. In 2024, we had not yet created sort of a specialist courts to handle armed robbery matters. Those are the ones that would draw us back quite a lot. So you would find that they were still being shared across everybody in the regional court, myself included. So these robbery cases, it's very few of them whereby you would find that it's a single accused person. There will be multiple accused persons, 4, 5, 6, even up to 10. I remember during the same period last year that you've referred to, I dealt with a case whereby there were about 10 accused persons. They were facing about 15 counts of robbery. And when you are dealing with such matters, they would not move with the same speed as you would expect, number one. Secondly, the computation of figures that we are using now would tend to cover up for some work that would have been done, but which will not be taken into account for purposes of completion of cases. Because we are saying, in the past prior to 2024, we were counting accused persons as a single case. The rationale being that, I'm sure it was something that was agreed at Antelope Park at a workshop there. There was some dispute, some discussion as to how figures can properly be computed so as to reflect the actual work the regional magistrate would have done, especially at Harare. That is where it is unique. So we used to count each accused person as a case, because each accused would give his own defense outline, each accused would do his own cross-examination. When you go to the defense case, each accused will stand to present his or her own case. Then it was changed in 2024. So the effect of that change is that amongst the 39, we will be having that particular case that I have referred to. Then you've done a trial, at the close of state case, they all make an application for discharge. We are going to sit down to write a judgment in respect of all of them to consider the participation of each one. You then discharge 3 or 4 for argument's sake. You then return a verdict of not guilty, and their cases are finalized. But for purposes of computation of figures, that is not taken into account, but we have taken time to write that ruling, consider the participation of everybody, then it would, at the end of the trial, be considered as one case. So the amount of work time would have taken to entertain that matter will then be overshadowed by that fact, because it is not being counted as one case, but it has taken a great lot of time to actually come to the end of the case. Then the other issue, sorry, AG, I'm about to finish. Yes, myself, I'm the senior regional magistrate for the Northern Division. The Northern Division includes the 12 courts at Harare Regional and 10 other courts that is outside, that is 3 courts in Mash East, 3 courts in Mashonaland Central, 4 courts in Mashonaland West. So you'd find that the time I would go out there supervising them or doing the M&E or going for purposes of the spot checks and whatever, that it would also subtract to the time I would spend in court, because I'll be doing that particular work. Then over and above that, if you check my performance contract, there are about 8 key result areas. Amongst those, there are about 4 that would require me not to spend 100% of my time in court. And I'm sure time and again, my boss would always remind me, please don't overdo the court work at the expense of other administrative duties. Then finally, yes. Then finally, I'm also involved in the training of magistrates, and at times there are some trainings that we do locally for Harare North and Harare South. We do them virtually and also nationwide. I'm also one of those trainers. So that would also eat part of my time in court.
Thank you for the explanation. Just one clarity about the release of accused persons on remand, like refusal of further remand. In this particular case, you refused to further remand 14 accused persons. Do you have an explanation? In fact, it's 14 matters, and judging by your explanation, perhaps one case is 10 accused persons, and there is a danger that you might have released over 100 robbers, alleged robbers, into the society. Would you like to also clarify this for the Commission?
Thank you, Attorney General. Insofar as robbery matters are concerned, we exceedingly slow in acting on those, taking into account that in the first place, the regional court do not even entertain bail applications for such persons. Regional courts, robbers, where there is an allegation that it was committed in aggravated circumstances, bail is applied at the High Court. So we are quite mindful about the seriousness of those offenses, and we are exceedingly slow in removing them from remand. Half the time, insofar as robbery cases are concerned, we do not refuse remand. We would instruct the trial prosecutor to get in touch with the officer in charge, homicide, or so that he would instruct the investigating officer to appear in court and tell us why the docket cannot be finished. Because what we have seen, I'm sure we have raised concerns in our criminal justice task force meetings, that we made an observation that there was a tendency of turning our remand court into a warehouse. They arrest people, stuck them there. And when you go to prison, I'm sure Commissioner Dube, the judge president, would agree with me what will be actually taking place in prison there. People will just be lumped there. There are no dockets that are coming. So we actually ask the prosecutor to actually ask the IO to come and explain to the court. So half the time those are removed from remand by way of withdrawal. It's only those other matters like you find that there is an attempted murder case, it is given 4 trial dates. And each time we are threatening the prosecutor, please rectify this. You have removed this case from the remand court and brought to the trial court. You are now turning my court into a remand court. If you don't take action, I am going to remove them from remand and you proceed when you are ready.
Thank you, Mr. Sikwa, for that explanation. And I would also like to qualify that the Commission is very aware that all accused persons have the right to be released on bail. In this particular case, I was just interrogating the release of so many accused persons at a time if you had such justification. Thank you very much, Chief Justice.
Thank you, Chief Justice, and good afternoon, Mr. Speaker. Good afternoon. So, looking at your career progression outline, to me, it's very impressive. It shows a lot of hard work, humble beginnings, but a lot of hard works and adversity overcome. But then I thought, look, unexplained, it might send perhaps wrong conclusions as to why it seems you started your LLB in 2003, but only got to be admitted in 2015. So perhaps I thought it's an opportunity for you to explain the circumstances why there would have been that much of a delay.
Thank you, Commissioner. The whole issue hinges on lack of finances. I was funding myself to study with the University of South Africa. And you see, when I started in 2003, that is when we started having these economic challenges until we got to 2006. UNISA closed all the exam centers in Zimbabwe. Those who were willing and affording would go to neighboring countries, Mozambique, Botswana, and so on. I did not have that kind of money. And if you can see, there is a gap, and I'm sure I resumed, it must be 2009 or 2010, when there was this dollarization. That is when I resumed, I restarted my study. Otherwise, there was a time I had to stop. I could not afford. Yes, that's the simple reason.
Thank you very much, Mr. Tsikwa. Thank you very much, Chief Justice.
Yes, thank you.
Thank you, Honorable Chief Justice. I have no questions.
Good afternoon, Mr. Tsikwa. Yes, I'm asking you just one question. What mechanisms exist under Zimbabwean law to enforce the right to equal remuneration for similar work provided for under Section 65 of the Constitution of Zimbabwe? That is my question.
This right to equal remuneration for similar work is guaranteed in terms of the Constitution, in terms of Section 65, subsection 6. It was then given effect by the relevant legislation, which is the Labour Act, in terms of Section 5(2)(a) of the Labour Act, which is that every employer shall pay equal remuneration for equal work of equal value. And the Labour Act did not just end there in making sure that it makes a legal provision for payment of such remuneration. In Section 5, subsection 3, it then goes on to provide for a criminal offense for failing to comply. In Section 63, it says anybody who fails to comply with subsection 2 of Section 5 shall be guilty of an offense and liable to a fine not exceeding level 8 or imprisonment not exceeding 2 years or both. So to my mind, that is a sufficient legal mechanism that has been put in place to ensure that employees are paid similar remuneration for equal work, irrespective of gender. I would not want to cite the relevant subsection, but I would say the same act actually gives an employee who has been disadvantaged by this discrimination insofar as payment of salary is concerned, is entitled to claim damages in the court. Thank you, JP.
Thank you, Mr. Tsikwa. Thank you, Honorable CJ.
Thank you, Honorable CJ. Good evening, Mr. Tsikwa. Still afternoon? Oh, it's still afternoon. Good afternoon, Mr. Tsikwa. My question goes like this. How does Section 90, capital letter A, of the Labour Act relax strict rules of evidence and procedure? And what limits remain to prevent injustice through procedural laxity?
Thank you, Chair, Chief Magistrate. In terms of Section 90, capital A of the Labour Act, the Labour Court is not bound by strict rules of evidence. The same section actually empowers the labor court to call any party, examine any witness, or cross-examine witnesses. The same act actually allows the labor court for the admission of evidence, whether it sees that it is just and appropriate and it would not prejudice any party to those proceedings. So as a safeguard, the Section 90A itself, it gives a catch that the court can allow or deviate from all these proceedings, or the requirements for the admissibility of evidence or the procedural issues. But the catch question is the labor court judge must make sure that it does not prejudice any party to those proceedings. And to also ensure that no party is prejudiced, Section 90 allows for parties to lead evidence before a determination is made by the labor court judge. So despite the laxity of those procedures, the right to lead evidence before the court was retained. So to my mind, that is sufficient safeguards to make sure that no party is prejudiced. Thank you, Chief Magistrate.
Thank you, Mr. Tsikwa. Thank you, Honorable Chief Justice.
Thank you, Chief Justice. Good evening, Mr. Tsikwa. I have one question for you. During your performance appraisal, your appraiser made the comment that you are to improve on insisting on staff discipline in order to get total control of the division. What is the problem with staff discipline and why have you been failing to contain it?
Thank you, Commissioner. To my mind, I never thought that the problem actually escalated to the extent of it being made a comment. Because like I've said, throughout my whole division, I did not have instances of people being charged with acts of misconduct. The only problem that I had, there was a clerk of court, assistant clerk of court, who was attached to the regional court at Harare. She was in the habit of abusing sick leave. She would abscond herself willy-nilly and she would give various excuses, she's not feeling well and that kind of thing. Until I then got the wind that no, it is not illness, it's drunkenness. She would come with little bottles of liquor, which each time she visits the toilet, she would take. So each time when she was presenting as if she was unwell, it was because she was intoxicated. So it's something that took me time to actually observe the real problem. That is the only problem that I am aware of.
As far as you are aware, you are in total control of your division.
I can say yes, Commissioner.
Thank you, Chief Justice. I have no further questions.
Thank you, Chief Justice. I have no question.
Are the following, you are a senior regional magistrate?
Yes, Justice?
Yes. Are the following regional magistrate under your supervision? I think it's Chivasa, Estere, Manuel Taurai, Mupindu Sandra, and Diraway Donald. Are these under your supervision as regional magistrate?
Confirmed, Chief Justice.
They are?
Confirmed.
Right. they have all appeared here exactly the similar to your conduct, where they have not been working. They have shown exactly the kind of conduct we are confronting you with. 2024, they were not working. There were some of them even removed the 55 armed robbers off the remand, just like you have done with your 14 from January to this year. They had not done anything more than the average. By this year, all of them, in fact, most of them had not done more than 19, I think 19 cases, like yourself, just 14. So it's a malaise in your department. It's a disease in your department. How is that?
Thank you, Chief Justice. The most unfortunate thing is, I'll go back to, but I've already admitted the figures that is given. The most unfortunate thing is that those figures were given here when we were already in these proceedings. But what I'm failing to understand is when we did our annual report, we actually meet our threshold, like myself as senior regional magistrate.
Let's not go into these figures. You have accepted them.
Yes.
This is data all of you have accepted. All of you want to be judges of the labor court, from your court. But there's clearly low performance, evidence of low performance, and you are the leader. You are the leader. Now we can see the source of these other judges' problems yourself. You have not been supervising them because you are behaving in the same way as they are.
Noted, Chief Justice. I don't think I would have further comment on that one, because that's already a finding. If I continue to try and explain myself, it might sound as if I'm being disrespectful, which is not appropriate.
Yes, I think you are quite right.
Yes.
Things are not right in your department. Definitely there's no performance to the standard we wanted, JSC. Far, far below the standard in the regional court at Harare. And all of you want to be judges of the labor court. Do you see where the problem is?
Noted, Chief Justice.
Yes. How does JSC even take that risk of getting judges from people who are at the low bottom of performance? Some of the regional magistrates, we have records here, already have tried 50 cases, where you and your other regionals we have had here have done less than 19, 14. So many flimsy excuses you are putting forward. Another magistrate has already done, last year was doing 105, taking over all the burden of this lack of performance from the other magistrate. 105. So it's far, far below performance, below the standard. You appreciate there's need for improvement?
I do appreciate, Chief Justice.
Yes, thank you. We have come to the end of...
Thank you, Chief Justice. Thank you, Commissioners.
Yes, confirm, we have Unzemoyo Godfrey Simbarashe. That, yes.
I confirm,
Thank
Honorable
you.
CJ.
As I said this morning, I'll be asking you 3 questions. The first question is as follows. What distinguishes a dispute of interest from a dispute of right under Section 93 of the Labor Act? And how does that classification determine whether arbitration is voluntary or compulsory?
Thank you, Honorable Chief Justice. A dispute of interest is a dispute which is other than a dispute of right. It is futuristic, for instance, issues to do with pay, and a dispute of right, it is a dispute over rights which are already determined. With regard to a dispute of interest, when it comes to arbitration, if it is essential service, that dispute must be referred for compulsory arbitration. Then if it is a dispute of right, it should be referred to compulsory arbitration. But however, when it comes to a dispute of interest, if parties agree, they can refer this dispute to voluntary arbitration. When the matter is referred for voluntary arbitration, the Arbitration Act is used, and in the first instance, a certificate of no settlement should have been issued, where after parties would have tried to conciliate the matter. Then the arbitrator who will be handling the matter has got same powers as the labor court, and on appeal, an appeal lies on a point of law only to the labor court against the award given.
The second question reads as follows. What steps must a labor court judge take to properly address and decide a constitutional question arising during its proceedings, if any?
Honorable Chief Justice, I'm kindly asking you to repeat the question.
You want me to repeat the question?
Indeed.
What steps must a labor court judge take to properly address and decide a constitutional question arising during its proceedings, if any?
Yes, in terms of section 1754 of the Constitution, if a constitutional matter arises in any matter before the court, there are 2 ways of handling the matter. A look at the Constitution, in the first place, has got may. That means to say that it is not mandatory. That is a situation whereby the judge can mero moto raise a constitutional question, then if the judge is of the view that there is a constitutional question to be determined before finalizing or disposing of an issue before the honorable judge, you would have to come up with a constitutional question which must be referred to the Constitutional Court. And in handling the matter, the judge has to call for parties to give representations on with regard to the question, to the constitutional question to which would arise. Then the words in any matter, it means to say that the matter is not yet completed. Then coming to the second part, where we have the word must, it means to say that at the request of a party, that party may raise a constitutional question, but it has got factors which need to be looked at on whether that request is not frivolous and vexatious. A plethora of cases has defined frivolous and vexatious as hopeless, groundless, and lacking seriousness. So those are the issues which have to be determined after one would have raised the constitutional question. Then the judge calls for the parties to give submissions, and it is the judge who must formulate the question to be determined by the Constitutional Court. And when that constitutional question is formulated, he must ensure that there is a draft order which is attached to the record, and that draft order is drafted by the party who would have applied to refer the constitutional matter.
The third and last question is as follows. What is the appropriate test for determining whether the Labour Court's factual findings are, quote, so grossly irrational, unquote, as to warrant appellate court interference in Labour appeals?
Thank you, Honorable Chief Justice. In the case of Hama versus National Railways of Zimbabwe, the test is that the conclusion reached is outrageous in its defiance of logic, such that no reasonable man would come to the same conclusion.
Yes, thank you. I'll hand you over now to the other commissioners to ask you questions if they have. Yes, DCJ.
Yes, thank you, Honorable CJ. Good evening, Mr. Unse Moyo.
Good evening, Honorable DCJ.
Yes, I have one question for you, which I will read slowly. Given the scope of the matters that appear before the Labour Court, can you list the possible agents that may represent parties before the court as highlighted by the Labour Court? Sorry, by the Labour Act.
Thank you, Honorable DCJ. In terms of Section 92 of the Labour Act, a party may be represented by a legal practitioner, can also be represented by an employee or official of a trade union or employers organization. With regard to a company, the company can be represented by a company director, company secretary, company legal advisor, a head of human resources, a head of personnel. Then the rules also supplement that on what is required. If it's a legal practitioner, they must file a certificate of agents. If it's a company, the company representative must file a company resolution. Then those from the trade union or employers organization, they must file their capacity to represent.
Yes, thank you.
Chief Justice, I have no questions.
Thank you, Chief Justice. I do not have any questions for Mr. Onzima.
Thank you, Honorable Chief Justice. I have one question. Good evening, Mr. Unzemoyo.
Good evening, Commissioner.
The question comes in two parts, and the first part is, how should the phrase redress any dispute in section 63(3)(a) of the Labour Act be construed? And the second part is, does it permit a designated agent to entertain appeals on the merits of a determination or only to initiate conciliation?
Sorry, Commissioner, I got lost when you said, does it allow the designated agent to initiate?
I will take it again. Does it permit a designated agent to entertain appeals on the merits of a determination or only to initiate conciliation?
Thank you, Commissioner Hogwe. Yes, the words redress have been described by the Honorable CJ in the case of Isoquent versus Darikwa. He ascribed two meanings or two options which the designated agent can take. The designated agent can firstly attempt to redress the matter. Secondly, one can redress the matter. And in that judgment, the Honorable CJ clearly stated that you cannot do both, you only do one aspect. Then, in the event that one redresses the matter, the determination is final. Then, when it comes to an attempt to redress the matter, thereafter, the aspect of conciliation then comes in. This section, it does not allow the designated agent to entertain appeals, but one can entertain conciliation.
Thank you, Honorable Chief Justice.
Thank you, Honorable CJ. Good afternoon.
Good afternoon, JP.
Yes, just one question from me. What mechanisms exist under Zimbabwean law to enforce the right to equal remuneration for similar work provided for under Section 65 of the Constitution of Zimbabwe?
Thank you, Judge President. The Labour Act clearly outlines the rights which women have, that they are entitled to equal remuneration for equal work, just like on the same basis, just like men. In the event that no equal pay would have been paid to women, it is an unfair labor practice whereby one can can report the unfair labor practice either to a labor officer who would make an effort to conciliate the matter within 30 days. In the event that they fail to conciliate the matter within 30 days, the matter goes to arbitration.
Thank you. Thank you, Honorable CJ.
Thank you. Good afternoon, Mr. Unze Moyo.
Yes, good afternoon, Commissioner.
Under the Labour Act, what is a collective bargaining agreement? What is a collective bargaining agreement? The second component of the question is, what are the prerequisites for its validity?
Yes, a collective bargaining agreement, as the word collective refers, it is a bargaining agreement between the employer and the employee. The requirement for it to be valid is that the collective bargaining agreement has to be registered. And in coming up with the collective bargaining agreement, one should note that it cannot be forced on the two parties, that is the employees or the employer. It is as a result of the two parties bargaining and negotiating and coming to an agreement. Thank you.
Yeah, beyond the two pillars that you advert to, that negotiation, that's number one, and then there is registration. Are there any other pillars beyond those two?
At the moment, Commissioner, apologies,
Thank you
can't
very
come
much.
up with any.
Thank you.
Thank you, Honorable Chief Justice. Good evening, Mr. Onzemoyo. I have one question for you. How does Section 90, capital letter A of the Labour Act relax strict rules of procedure and evidence? And what limits remain to prevent injustice through procedural laxity?
Thank you, Commissioner. Section 90 of the Labour Act speaks to the relaxation on strict rules of evidence. It provides that the Labour Court is not bound by strict rules of evidence, and this is also supplemented by Rule 12 of the Labour Court rules. When the judge is dealing with such matters, to prevent injustice on the other party, the judge must also look at the interests of the other party who is involved. The main purpose of the Labour Act is enunciated in Section 2A of the Labour Act, is to push for social justice and democracy in the workplace, and by having informal proceedings. The reason for having SEM is because laymen also appear before the court. So they do not have to be bound by strict rules of evidence. I'm forgetting the particular case law, but one written by the Honorable DCJ, where she was saying that laymen also appear before this court, so it must be easy for those who litigate in this court to be able to litigate because they do not have the expertise which lawyers do have. Thank you.
And the other part, which says what are the safeguards in place to ensure there's no injustice in the labor court? You did not address that one.
Yes, coming to the issue of safeguards, the court has to, like I indicated, has to look at the interests of the other party. Then the court also has to ensure that there is not too much laxity. Otherwise, there will be chaos in the court.
That is your response? Okay, thank you. Thank you, Honorable Chief.
Thank you, Chief Justice. Good evening, Mr. Unzemoy.
Good evening, Commissioner.
I hate to have to ask you this. The adverse report from the judge. You have seen it, you have put up a very spirited defense. Can you explain what is happening?
Thank you very much, Commissioner. I went through the report. I came up with a response. I wouldn't want to say much, but I was of the view that the comments made on me I'm of the view that the comments which they came up with are not justified because having been a magistrate determining matters, I do not have so. If my memory serves me well, the white papers which would come through the High Court, which I would get as feedback, very few white papers. Then currently I've been in private practice from around October 2019.
Let me stop you there. This judge was commenting purely on your work as a magistrate. This lengthy response that you put in spoke a lot to your work as Deputy Registrar in the High Court, which was after your very lengthy stint as magistrate, because you were a provincial magistrate in 2016, isn't it? You had been a magistrate for quite a good number of years. Then you went to the High Court as Deputy Registrar for about 3 years, isn't it?
Indeed.
And after that, you then had a short stint of 3 months as a magistrate. It's not clear to me if the judge was speaking only of your 3 months as a magistrate in 2019, but my impression was that she was talking of the years you were a magistrate before you went to the registry. I can see the good things you did when you were in the registry, but my concern is that you didn't really respond in the event that this report relates to your time prior to the registry. Telling us about the wonderful things you did in the registry does not really answer to what happened in the previous period when you were a magistrate, in the event that the judge's adverse comments relate to that.
Thank you, Commissioner. Indeed, I was a magistrate for a long time. The adverse comment which I saw and read, I'm of the view that it's not justified. The work I was doing up until 2016 when I was seconded to the High Court, my judgments were quite coherent, they were quite clear. they would show that indeed there was substance. I never got negative feedback with regard to how I was writing my judgments. After I would send my work for reviews, even my records on appeal, there isn't any negative feedback which I got. That is why I came up with the view that I do not think those comments are justified. During my time when I was a magistrate, I was a person who was not struggling. That is why in my report I was clearly showing that upon transfer to Mashonal and Central, I pushed quite a lot with working as a team with the others to reduce the backlog there. In as much as I was completing many cases, I was not getting any feedback on the judgments. I was writing the determinations which I would come up with.
In your response, you say there must be some sort of mix-up. Do you think the judge might be confusing with somebody else? Do you think it's a case of mistaken identity? Because otherwise, you are now asking us whom to believe between you and the judge.
The reason why I was saying there could be a mix-up is the work which I was doing, like I indicated in my report. Some of the honorable judges would inscribe some comments on top of the review minutes they will be writing, giving positive comment that this is a good analysis. So if someone would come up today and say what you were writing was not coherent, it doesn't show that you know the law, it's not justified. That's why I was saying there could be a mix-up. But if you look at the comment, it's written as if I am still a magistrate. Yet I left sometime in 2019.
Thank you, Chief Justice. I have no further questions.
Thank you, Chief Justice. I have no question.
So since 2019, when you went into private practice, you have not appeared at the labor court.
I confirm the position, Honorable Chief Justice. Most of the cases I've been assigned at the law firm where I am currently, most of the matters I am doing end up at conciliation and arbitration. My cases have not gone beyond that level.
Yes, thank you. We have come to the end of your interview. You are excused.
Thank you, Honorable Chief Justice, for the opportunity, and thank you, Commissioners.
All right. 10-minute health break. confirm we have Ziaduma Garudzo.
Yes,
Yes.
Honorable Chief Justice.
Thank you. As I indicated this morning, I will ask you 3 questions. The first question is as follows. What distinguishes a dispute of interest from a dispute of right under Section 93 of the Labor Act? And how does that classification determine whether arbitration is voluntary or compulsory?
Thank you, Chief Justice. A dispute of right is a dispute or a disagreement between an employer and employee which relates to rights which are clearly defined, whether in terms of legislation or in terms of the contracts, whether in terms of the collective bargaining agreement or in terms of regulations. So that is the dispute of right, or it can relate to an unfair labor practice, or its actual or an alleged unfair labor practice that relates to the dispute of right. And a dispute of interest is a disagreement between an employer and employee that relates to changing of the current state of affairs to try and introduce new rights between the parties. And for a dispute of interest, what has to be taken note of is that in cases where it arises, normally the arbitrator or the labor officer or the designated agent will try to conciliate the dispute or attempt to redress it. If they succeed in doing that, they issue the certificates of settlement. If they do not succeed in doing that, they refer the matters for arbitration. And when it relates now to a dispute of right, the referral to, it's always referred to compulsory arbitration. It's not voluntary in relation to a dispute of right. It's always a compulsory arbitration. The reason being that the intention is to settle these disputes as expeditiously as possible. That is my answer.
The second question is as follows. What steps must a labor court judge take to properly address and decide a constitutional question arising during its proceedings, if any?
Thank you, Chief Justice. When a labor officer
is faced with a constitutional matter during the course of the proceedings, he has to adopt the stance that is outlined in section 175, subsection 4, which is to the effect that if in the course of proceedings a constitutional matter arises, it's either the court may merimotu decide to make a referral of the matter if the matter is so important for the determination of the issue that is at stake before that court. He may do it merimotu or on his own initiative, or the referral may be at the request of any of the parties appearing before him. What happens when the judge decides, merimotu decides, or it's court-driven, the process, is that the judge will invite submissions from parties that are appearing before him after he has identified to them that this is the constitutional issue that I am observing from the case, and that ought to be referred for a determination. And that is also very critical in the determination of the dispute that is before him. So when he does that, he invites the parties to make representations or submissions. And if there are disputes of facts in relation to that, there has to be evidence that has to be led by the parties appearing before him, and he has to make a determination, especially to resolve the factual issues that are arising before him. Or it may happen that the parties have no dispute in relation to the facts that are there, and in that event, they draft a statement of agreed facts relating to the facts. So in that case, there won't be any need for the judge to then resolve the disputes of fact, because he simply attaches to the referral the statement of agreed facts. So when the representations are made, then he constructs the constitutional question for referral. Then when he does that, he submits then to the registrar, who then forwards it to the Constitutional Court. That is in relation to a court-driven process. But if the process is being initiated by any of the parties, again, evidence has to be led, especially outlining why a party is of the view that an important constitutional matter has arisen, which ought to be determined before the main matter can be resolved. So the courts have highlighted that in submitting the referral, it should happen in the course of proceedings before the court. And if the proceedings are terminated, the referral will be incompetent. That is what our courts have highlighted. And when the referral before the referral is made, the court also has to make a determination on factual issues again, as what happens also when the process is driven by the court. And what is also important is that a court has to be a court of law. So the referral will not be incompetent if it is being referred by a tribunal or administrative functionary. It will not be a competent referral. Yes. So this is largely the procedure that has to be followed by the judge in the labor court. Thank you, Chief Justice.
The third and last question: what is the appropriate test for determining whether the labor court's factual findings are, quote, so grossly irrational, unquote, as to warrant appellate court interference in labor appeals?
Yes, thank you, Chief Justice, again. When a determination is being made on whether a court's decision or findings are grossly irrational, normally you consider whether the court has, in its decision, considered irrelevant facts or material in coming up to a decision. Or one may also consider the fact that the decision itself that has been made is devoid of any rationality or connection to the facts that has been placed before the court. That is my answer.
Yes, thank you. I will now hand you over to the other commissioners for further questions if they have. Yes, CJ.
Thank you, Honorable CJ. Good evening.
Good evening,
Mr.
Deputy Chief Justice.
Duma. I have one question for you, and it goes as follows. Given the scope of the matters that appear before the labor court, can you list the possible agents that may represent parties before the court as highlighted by the Labor Act?
Thank you, Deputy Chief Justice. The parties may be represented by legal practitioners who are registered in terms of the Legal Practitioners Act. Secondly, they may also be represented by representatives from trade unions or employers' organizations. They may also be represented by the directors or company secretaries or any person from the human resource department of an organization. Thank you.
Yes, thank you for your answer.
Thank you, Chief Justice, and good evening. Now,
Good evening, Attorney
yes,
General.
you have mostly been a public prosecutor and dealing mostly with criminal matters. Now, can you tell the Commission how are you going to ensure a smooth transition if you become a judge of the Labor Court?
Yes, thank you, Honorable Attorney General. I've been a prosecutor for almost 2 decades, that is correct. And if I'm appointed to become a judge of the labor court, I'm of the view that my training as the public prosecutor has sufficiently trained me to assume that particular role, because prosecution is a specialized area where, albeit we deal with criminal matters, and the capacities that has been ingrained in me in the process of prosecuting, I'll say, legal research and presentation. It's a capacity that I have been trained to dish out, and that I've been trained to master. It's an art that I've been trained to master, and I believe if I'm appointed, this will also assist the labor court in that particular view. I've also, to demonstrate that I've mastered the issue of legal research, I've also highlighted even in my submissions to the commission that I've written a dissertation on alternative dispute resolution, which is different from criminal law that I normally deal with, showing that I have an interest in that particular area. I also believe that if I'm appointed to be a judge, the ability to communicate is something that is also trained in the work when one is a prosecutor, and that is also something that is a tool that is needed in the office of a judge of the labor court. And additionally, I've also been involved at workplace in disciplinary proceedings, especially from the investigation stages of misconducts, and also to chairing some disciplinary processes. And in so doing, I've been exposed to even some of the principles that are evident in the Labor Act and also in the labor rules.
In other words, do you have any exposure, or have you interacted with the labor court in the past, you say, 10 years?
No, I haven't interacted, but I've only sat in disciplinary processes at workplace.
Do you have any experience in other alternative dispute resolution methods, such as mediation or arbitration? Do you have that experience?
No, I have no experience in that, but the only other alternative dispute resolution method I was involved in, like I highlighted in my documents, is that I've also engaged in pre-trial diversion processes, which are also an alternative dispute resolution method, where minors in conflict with the law are removed from the criminal formal justice system.
Yes, thank you very much, and thank you, Chief Justice.
Thank you, Chief Justice. Good evening, Mr. Ziatuma.
Good evening,
Yes,
Commissioner Masie.
Thank you. Now, the question from me is as follows, right? What are the potential legal consequences for an employee who resigns without giving proper notice, and how should the labor court interpret such a resignation under Zimbabwe's labor legislation and principles of fairness?
Can I have the last part of the question?
What are the potential legal consequences for an employee who resigns without giving proper notice, and how should the labor court interpret such a resignation under Zimbabwe's labor legislation and principles of fairness.
Thank you, Commissioner. A resignation is a unilateral act by an employee to terminate his relationship with an employer. And when an employee resigns, normally Section 13 of the Labor Act kicks in the sense that an employee will be entitled to payment of his outstanding wages if he had any, and also the vacation leave days, and also he has to be paid his pension. And so when he resigns, these items, if they are, these issues, if they are outstanding, have to be honored by the employer, and it is a criminal offense for him not to honor that part. However, when the employee, if the employee is indebted to the, or has a debt to the employer is allowed to deduct the sums of amount owing to him when the resignation is given effect to. And the second part of the question, how does the Labor Court interpret such a resignation under Zimbabwean legislation and principles of fairness? Normally, you cannot force someone to continue to have a relationship with you at work. So the only recourse that the employer will have is possibly the deduction of amounts owing to him. And if the employee was supposed to give sufficient notice as stipulated within the Labor Act, and he has not done so, the employer may resort to deduction of amounts equivalent to the period of time that you are supposed to give notice to. Thank you.
Thank you. Yes, but on the second part, we are still addressing the employer. We are still talking in respect of the employer. The question, remember, speaks of the Labor Court, right? How would the Labor Court interpret that kind of resignation? Are you happy with your addressing that aspect? Because I didn't hear you addressing.
Normally, my answer that I had related to was specifically speaking to considerations that the Labor Court will take when it is now dealing with a case involving resignation. Yeah.
Thank you very much, Mr. Zetuma. Thank you, Chief Justice. Thank you.
Thank you, Honorable Chief Justice. And good evening, Mr. Ziadu.
Commissioner?
Just for clarity, when did you register as a legal practitioner? And effectively, that is when you started legal practice as a legal practitioner?
I had gone through the Judicial College of Zimbabwe in 2001 and completed my studies there in 2002. So I started working as a prosecutor in 2002, around July.
So when you say in your questionnaire at page 3, and I quote, I have been in continuous legal practice from 2002 to date, you include the period before your registration as a legal practitioner.
Precisely, Commissioner.
Thank you, Honorable Chief Justice.
Good evening, Mr. Ziaduma. Just
Good
one
evening.
question from me. What mechanisms exist under Zimbabwean law to enforce the right to equal remuneration for similar work provided for under Section 65 of the Constitution of Zimbabwe?
Can you come again with the last part of the question?
Yes. What mechanisms exist under Zimbabwean law to enforce the right to equal remuneration for similar work provided for under Section 65 of the Constitution?
Yes. Thank you, Judge President. Under Zimbabwean law, the Constitution firstly indicates that men and women are supposed to get remunerated equally for similar work that has been put in place. And to operationalize this, in fact, maybe we'll start with what Section 56 of the Constitution also says, because it discourages discrimination based on sex. That is what it discourages. And the Labor Act also recognizes the same principle in, I think it should be Section 5, if I'm not mistaken, of the Labor Act, which operationalizes this particular right as contained in the Constitution. Thank you.
Consequences of failure to comply with these requirements of the law?
A party who fails to comply with this provision commits, firstly, an unfair labor practice, and because of that, litigation can be instituted against them.
Thank you. Thank you, Honorable CJ.
Thank you very much, Chief Justice, Mr. Ziaduma. Good evening.
Good evening, Chairperson.
I've got
Dr.
a two-part question. Under the Labor Act, what is a collective bargaining agreement? What is a collective bargaining agreement? The second part of the question is, what are the prerequisites for its validity?
Thank you, Dr. Ongwe. A collective bargaining agreement is a voluntary or agreement that an employers organization or employers and employees negotiate for. And this collective bargaining agreement will contain a number of issues that are important in the work relationship between the employer and the employees. But basically, this is an agreement that is born out of negotiation between the employers' representatives and also the employees' representatives. We have been authorized to negotiate on behalf of the parties. That will be the answer for the first part of the question. And in relation to the question, what are the prerequisites for its validity? Normally, before the negotiations begin, it is expected that the parties, rather the representatives of the two parties, they should demonstrate that they have been authorized to represent the parties that they claim to represent. And the manner in which they demonstrate that is that they have to produce something in writing which confirms even the areas that they've been authorized to agree on or discuss on or to negotiate on. And this has to be signed by the parties that are sending the representatives. And when these discussions now are starting, there has to be, the discussion has to ensure that there should be bona fides, rather, the duty to discuss in bona fides by the parties. There is no party who is supposed to hide something from the other in the negotiation process. So it's also important for the negotiations. And to the extent that the duty to discuss in bona fide, and it relates even to the disclosures that are to be made by the parties during the process of discussing for them to come up with the collective bargaining agreement. Each party has to produce even documents that are necessary for the discussions or for the bargaining process. And it might happen that one of the parties may not be engaging in the discussions in good faith, and they may make certain misrepresentations in the process. And however, the party who is aggrieved by that is allowed to, in fact, is allowed to have resort to, my apologies, I will take that again. So when these people are now engaging in the discussion and it's apparent that someone has fraudulently made certain representations, then the aggrieved party is allowed to approach the minister for the rectification of that particular misrepresentation. And in other words, the party who is said to have made misrepresentation is then required to produce a certain information, or rather information to demonstrate that they might not be lying, or the other party who is alleging that this person is misrepresented can produce also information to that effect. If the parties are agreeing, it is also important that they go back to their constituencies for ratification of whatever areas that they would have agreed on. Then after the parties have obtained the ratification, they come back for the negotiation. The document that they come up with is then submitted to the registrar for registration firstly, and after it's registered and it's referred then to the minister, who then publishes it, and then it becomes law. That is the process. Thank you.
Okay, thank you very much. It's pretty much the pillars: negotiations, ratification, registration, and publication, right? Those are the pillars that pretty much constitute the basis upon which validity is rendered to a collective bargaining agreement. Yeah, okay, thanks.
Okay, thank you.
Thank you, Honorable Chief Justice. Good evening, Mr. Ziaduma.
Good evening, Chief Magistrate.
I have one question. How does Section 90, capital letter A of the Labor Act relax strict rules of evidence and procedure? And what limits remain to prevent injustice through procedural laxity?
My apologies, can I have the second part of the question?
What limits remains to prevent injustice through procedural laxity?
Thank you, Chief Magistrate. In terms of Section 90A, I think I should be right. It says the Labor Court does not follow strict rules of evidence. And to try and manage that particular provision, it also goes in the same sentence to say, unless if it is unfair to the parties. So one way of trying to limit the laxity is to say if it is unfair in any way to any of the parties appearing before it, the rules may not be relaxed. And additional safeguards that are also within that provision are that the parties to the dispute are allowed to cross-examine a witness brought by the other party. And the court also, in addition to the parties, can also cross-examine or put questions rather to the parties. And in putting questions, it might be putting the versions as obtained from the parties for clarification from the witnesses. So in that way, it plugs the procedural laxity. That is my answer.
Thank you very much. Thank you, Honorable Chief Justice.
Thank you, Chief Justice. Mr. Ziaduma, I want to take you back to the question that Commissioner Hokwe asked you, because I don't think you appreciated the gravity of it, judging by the answer you gave. Commissioner Hokwe referred to your nomination form where you accepted nomination to the office of Judge of the Labor Court. You certify that you accept nomination, then you make the following comment: I have been in continuous legal practice from 2002 to date. That is what you wrote. You are aware that it is a constitutional requirement that for one to be considered for the office of a judge, one must have been qualified to practice law for at least 7 years. You are aware of that?
Precisely, Commissioner.
So you understand that qualification to practice law is an integral qualification?
Yes, I do appreciate that.
At what point does a person become qualified to practice law?
It is at the point of registration.
And you were only registered in 2015, but you are claiming that you have been practicing law continually since 2002. Do you appreciate the gravity of Commissioner Hokwe's question?
Yeah, in hindsight now I appreciate, but maybe to answer to that, I've been appearing in court for the period that I've stated, but in terms of registration, my registration starts from 2015. Hence, it might be corrected in light of that, because I've been doing the same duties I've been doing even before I got registered. But I appreciate that particular point.
I'm not sure you do. Please switch off your mic. We can't have both of them on at the same time. I'm not sure you appreciate it, because it's a grave misrepresentation. This is a constitutional requirement that you must have been qualified to practice law. So for an aspiring judge, you cannot use that term loosely to refer to having been a prosecutor. Certainly you've been a prosecutor since 2002, but you've not been qualified to practice law since 2015. So when you say I've been practicing law since 2022, for the purposes of this exercise and for the appointment of a judge, it's a serious misrepresentation that I think you need to correct.
My apologies for that. And with the rider that I've been practicing from 2015, and I've also met the constitutional requirement of the 7 years of practicing. Thank you.
That is not an issue. The issue is that a judge must understand the nuances of the law and cannot afford to make a mistake like that. That is the point that I'm trying to make you understand, but I'm not sure I've succeeded. But thank you, Chief Justice. I have nothing further.
Thank you, Chief Justice. Good evening.
Good evening, Commissioner.
Yes, I think I have one question for you. The question reads, does the Labour Court have unlimited jurisdiction over all labour matters?
The powers of the Labour Court are as contained in Section 89 of the Labour Act. And these powers include the power to hear appeals and determine applications. In terms of unlimited jurisdiction, this is a specialized court that has been created specifically to be dealing with labor matters. And it is the only court that, rather it is the first appellate port of call from work that comes in from the district designated agents and labor officers. And in the appellate side of things, but it indeed has unlimited jurisdiction in relation to labor matters that come before it.
Does that mean all labor matters?
As defined, in fact, its powers are derived from Section 89, as I have highlighted. And it cannot act outside the provisions of Section 89.
Okay, thank you. No further questions, Chief Justice.
Yes, thank you. We have come to the end of your interview. You are excused.
Thank you, Chief Justice. Thank you, Commissioners.
Thank you. Just confirm we have Zuyu Judith.
Confirmed.
Yes, thank you. As I indicated this morning, I will be asking you 3 questions. And the first question is as follows. What distinguishes a dispute of interest from a dispute of right under Section 93 of the Labor Act? And how does that classification determine whether arbitration is voluntary or compulsory?
Thank you, Chief Justice. A dispute of interest is a dispute to get an advantage. For example, the need to get a pay rise.
If you can raise your voice so that we hear you, all of us.
Thank you. A dispute of interest is a dispute to get an advantage or a benefit. For example, where an employee calls for a pay rise, where there's a dispute on a pay rise. Whilst a dispute of right is a dispute that involves rights and obligations. Which involves a breach or alleged breach of an act, that is the Labor Act, or a regulation under the Labor Act, or a term of a collective bargaining agreement. A dispute of right, again, also involves a breach or alleged breach of a term of an employment contract. Then the second question, how does it determine whether to go by arbitration voluntary or compulsory?